why every human being deserves a dignified life. That is what, while interpreting this particular right to life, fundamental right, which is enshrined in Article 21 of the Constitution, in iota of judgments, Supreme Court, High Courts, all our constitutional courts have very rightly said that right to life doesn't mean right to life per se. It is right to life, rather right to dignified life. A step ahead, Supreme Court, I remember in a judgment, has stated not only right to life, right to dignified life, but right, which is enshrined in Article 21, is extends to the to the extent that right, everybody has a right for a dignified death. So that is what is the important, uh, very important thing. Why this is so? Because we are different from other flora fauna which we find in the nature. And what makes us different? What is the different? The most important thing, what I feel, is that it is because of our intelligence, it is because of our reasoning, it is because of our rationality that we are different from other uh, animals, other flora fauna on the earth. And that is why this most fundamental of the all fundamental rights, human right, is given to us, and that makes us different. Now, because of because of this difference, as I said, the freedom to take any kind of decision, freedom to take to do anything, and basically this everything goes to the core of intelligence. That's what I wanted to say. And you can't basically set frontiers for this intelligence, no restrictions on intelligence, as far as if we talk about the intelligence. So so human being is given a specific a, a different identity is created, is there, and we've been given this important right, and that is what we are superior from the other flora fauna, as I said earlier. But and with the help of this intelligence only, you create all kind of all sort of intelligence, all sort of technology, all sort of innovations, all sort of developments which we see. But here, when you talk about this development, this intelligence, here, when with this intelligence only, if I may say one more thing, if with this intelligence only you can create any limb, you can create hand, you can create lungs, you can create heart, you can replace them. But the moment we create a mind, I feel this is an alarm. It has lot of positivities also. you know AI has lot of positivities. If I may say, in the field of medicine, in almost in the field of technology, various other technologies which are serving human being, this is a great thing. But if we confine ourselves to the law per se, that then there are so many positive things. Let me give one or two examples then, which are very, very important. Like, if you have to do some due diligence, I think artificial intelligence is one of the very important, is playing now a very important role. I remember when you have to do some due diligence, legal due diligence of a company, it would have taken 6 months' time. If we are doing it on the basis of individual resource, a human resource is only exclusively working, doing all running around, where are the cases going on, which are the cases, reading the material, what is, all that kind of what will be the outcome, and so on and so forth. But where we use the services of IA, we see that legal due diligence takes very less time. Legal research, same thing applies to the legal research. We have seen so many legal softwares. We have seen, and you see that this it comes to my mind very swiftly, if I may talk about automation of documentation. We see very quickly it happens. If you see it from the point of view of a law firm, if maintaining the record, which date is, if today, if you have, I have seen it at many places, the automation is such that even next dates and all the smaller, maintaining the diary, all those which we used to do earlier by hand, everything is now automized. So making electronic bills and so on and so forth. So it has great positive impact upon the from the point of view of law firms. So I'll not take much of time because I think my time is limited. We have got so many specialists who are there, galaxy of intelligent brain who are sitting here, and they'll be sharing the wisdom, their wisdom here. And with that, I would request Professor Dr. T.S.N. Shastri, founder vice chancellor of National Law University Sikkim. I would request sir to please come and enlighten all of us. Thank you very much.
Good evening to one and all, and good afternoon also, since we are conducting the global conference. Honorable Justice Madam, Mr. Sanjay Kumar Chadda, and other dignitaries across the globe. I'm extremely happy to share few of my viewpoints on the artificial intelligence and human rights. Well, I'm extremely happy that the conference has been titled as Law and Peace. That itself clearly shows that there is a need to discuss law and peace in the world today. We are not living in a world of peace. We have a lot of disturbances. On various fronts, we have the disturbances. And we see the various aspects that affect us in various ways and various perspectives. Well, knowledge has no boundaries, no limitations. Knowledge system committed to the notion of generating behavior by means of deduction from a set of axioms. This single sentence gives us a lot of meaning that how we progress and how we develop with respect to various aspects of knowledge. Exactly, this is what the point might have culminated the framers of the UDHR while framing the various provisions of the human rights, particularly while bifurcating the principles into civil and political rights and socio-economic cultural rights. I invite the attention of all the learned speakers, panelists here, that let us look into Article 15 of the Covenant of Economic and Social and Cultural Rights, which speaks of expansion of cultural property for the peace and progress of human rights. So cultural property, that is science and technology. In law, science and technology is part of a cultural property. So this cultural property deals with various aspects. And we should be very careful with its expansionist perspective is considered. We think that technology is everything in today's world, unfortunately, forgetting the most important perspective of ethico-moral legal value systems, which have been very important for the development of cultural perspective, particularly science and technology. If we forget the basic principle of human rights, whatever the scientific perspectives that we develop, they may not yield good results for the augmentation of the society. This is what, when Locke proposed the principle of mental moral labor theory, which is today called as intellectual property rights. Because when Locke was advocating, he advocated the moral ethical principles of labor, including mental labor, which intellectuality, intellectual property is also a labor. That's mental labor. This has been expanded in various angles by people. But unfortunately, the perspectives that have been advocated, the radical principles that have been advocated, particularly the progressive perspective of ethico-moral rational behavioral perspective of Immanuel Kant, has been forgotten. Well, Immanuel Kant's philosophical perspectives have been further advocated by many other philosophers dealing with the various perspectives of justice and justice system. But all these problems today we are facing, and the West suddenly started realizing that we should not speak of rights, we should speak of duties. And we are on a divided platform because the Eastern culture, you take Japan, China, India, the ancient Eastern culture, or till date, this culture of these countries have advocated duty orientation than right orientation. There is a big debate going on in the world with respect to the human rights jurisprudence. As a student of human rights for the last 30 decades, if you ask me what are human rights, I can only give an answer. I'm had to learn what are human rights. Because had Madam Eleanor Roosevelt made it, where do you find human rights? This is the starting point. In small places, in the place where a person is suffering, in the place where the workers are suffering, in the place where the people who doesn't have food, you find human rights there. Not in aristocracy or in five-star hotels or in palaces. Human rights are found there to give social justice. Thanks to the constitutional framers, particularly the drafting committee chairman, Dr. Babasaheb Ambedkar, has given 4 important ingredients to the Constitution of India. That is justice, liberty, equality, fraternity, if we read from the preambular perspective. But according to Dr. Babasaheb Ambedkar, it is fraternity which is first, liberty is second, equality is second, liberty is third, then you think of justice. When we don't have a fraternity, when we don't have equality, we are not entitled to talk of liberty or justice. This is the intertwined principle of human rights jurisprudence advocated by the epitome of the Constitution of India. This is the only constitution in the world which has advocated very clearly the ethico-moral principles of human rights, because there is a good coincidence. The 1948, the UDHR was adopted. 1949, the Constitution of India is adopted. So we had a very good opportunity to take the entire philosophy, even before the world divided the civil and political rights, socio-economic, cultural rights of UDHR into two perspectives. Constitution of India in 1950 divided fundamental rights and directive principles of state policy. Unfortunately, without looking at, many of the law professors and law teachers and law students say Indian constitution is a borrowed constitution. It is not. It is the greatest constitution which has contributed a lot for the development of the world. Unfortunately, without understanding the ethos, values of the constitution, left and right, we are amending the constitution on the name. It is a living document. Why I'm saying this? When you have a constitution, when you have a defined power, when you have defined principles, after 7 decades also we could not achieve the principle of social justice advocated by the constitution. In international community, which doesn't have states, means superior emperor, but only sovereign states are the members, how could we achieve and how can we expect them to achieve the objective principles, ethico-moral value-based principles of human rights? This dichotomal perspective, without understanding the prism, because if we see Universal Declaration of Human Rights, Article 29 clearly advocates that the rights that are stated in this declaration can be realized only upon discharging the duties that are entrusted. Unfortunately, we have forgotten the duties. Almost all the countries in the world. We only talk rights. But the ancient Eastern culture, particularly that of India, talks of the principles of and ethico-moral principles of law and justice system, which advocates very clearly, whatever you may be the position, the law is supreme. If we take that presumption, the expansive perspective of knowledge that started, culminated in early 70s with the expansion and invention of Milli and Mini by the British scientists to bring in the Human Genome Project, has expanded, though the United Nations stopped the further progress of the Human Genome Project. I don't want to go into biotechnology and others, this being artificial intelligence, that led, then the United Nations stopped. The perverted mind of the human being has gone further development of science and technology, which is a very expansive idea because of science, development of science and technology, information technology. Today, people sitting across, today this conference itself, we are in the evening, some of the speakers are in the afternoon. We are able to speak and see each other. We salute the scientists. But when the scientists make their knowledge, forgetting the ethico-moral values, as advocated by the great philosophical jurist John Rawls of justice system, should be to do justice to the social justice principle and also to help the people, those who are languishing for justice. On that principle, let me explain, since there is no definition that exists on defining artificial intelligence very clearly, but I'll give you 3 important definitions. Of one of the founders, Mervyn Miniske, has said, the science of making machines do things that would require intelligence if done by men. The second definition by John McCarthy defines the science and engineering of making intelligent machines. The third, very recently, the Stanford University has come out with a definition, a science and a set of computational technologies that are inspired by, but typically operates quite differently from the ways people use their nervous system and bodies to sense, learn, reason, and take action. If we see these three definitions, what is artificial intelligence? It is only information technology, or is it feeding the ethical principles that have been stopped not to violate the human caricature into a separate thing through the Human Genome Project by United Nations? The pervertedness of the scientists led to create missions to replace the human being. In this regard, a decade back, almost, we got a most important scientific movie, Robo, by Rajinikanth, which gives a clear picture that how the value system can be corrupted by illegal minds in the society. The Robo was created with a good intention, but another scientist wanted to spoil it, to spoil the name of another scientist. That is the egocentric clashes of human beings. By forgetting the human ethical values, the artificial intelligence that is created will, instead of helping, will bring problems to the existence of human world and human beings. Do we need such principles of artificial intelligence? Question, $1 million question. There is no straight answer to this. The second is, are we going to become slaves of the machines? Another $1 million question. We have become we proved to be slaves, because there are a lot of messages, if you see in social media. It happens also in a family of 4 or 5 members sitting at having a very costly gadget of a mobile phone. Each will be calling and each will be talking over mobile phones to within the 4 corners of the same house. Then where is humanness of human rights? I'm asking the basic question. Because Locke has propounded property and the perceptions of intellectual property rights. But with respect to artificial intelligence is considered, there is no patent can be claimed. Only copyright can be claimed. And copyright has a lot of restrictions. Copyright has mental, moral, ethical principles should be taken in copyright. We have forgotten that. No patent can be claimed in artificial intelligence or scientific technology or other things are considered. Then are we safe with the technology? Is technology bad? Technology is not bad. The invention of technology is for the good. But when we misuse the technology, when the societies are not upgraded or the people are not educated to use the technology for helping your assistance, then you become a slave. Today, many people say, what is this calculation that you can do? Immediately they open a mobile and they open a calculator and say, no, my mobile is working, my system is not working, so I cannot give you. That means how slavish that we have made the computer of computers, the human brain, not to work. There's a fundamental principle to all the learned colleagues. They may agree, may not agree, but this is the truth. Because in these days, speaking truth is also a problem. But don't speak. Don't start or don't stop speaking truth. Because the Indian Constitution or the Indian emblem of Ashok Chakra says, Satchameva Jayate. The very great principle to be inculcated to teach a lesson for the perverted misusers of artificial intelligence, not to all. One. Two, what are the vulnerabilities? I'll not take much time. I'll just quickly go to what are the vulnerabilities. The vulnerabilities are your big data. You don't know what is the data. Suppose you say use a particular thing, then it if you purchase a thing in an online shop, it gives a big contract which is not visible in small letters. The Privy Council long back made it very clear, if any contract is made, it should be clearly, visibly brought to the knowledge and notice of the person. Only lawyers and law students will know, but other people doesn't know. So you simply say, I accept. Tomorrow something goes wrong, you can't file a case. The fellow will say, you have accepted my agreement. And if you don't accept, there is no option to modify the agreement. You are forced. Where is your consumer rights? This United Nations never wanted from any perspective. Unfortunately, we became slaves of that. Then the data mining, machine learning. Everything is compressed into the data and you have to learn only through the mission. You can't do individually reading a book or anything. If I want to use something, I have to go to Google and search. So not today for research, for many people, Google became anything else than a textbook. Then the third one is deep learning. If you understand scientific technology, you need a lot of learning about it. The small letters will be there. By reading the small letters, sitting in the system for days together, definitely it will lead to nervous weakness. It will bring in a lot of health hazards. I need not explain. Particularly, your retina power will decrease and you depend upon glasses. And after some time, you may become completely blind also. Do we need such information storage in mission instead of retrieving into book form? This is another principle that violates the basic human rights perspective. Because one day, speech recognition, you speak something and you go to the computer and say, and give the voice that is symbolizes into various digital performances. So if you are a computer generic fellow, you know the technology, you can alter the speech and incorporate words which has not been used by the original speaker and misuse him and then defame him. This is another important bad thing of misuse of technology. I'm not saying Article 15 of ICSR says culture and cultural perspective to be developed, but for the development of social justice, not for anything else. Then natural language. You lose now a language. India, a kaleidoscope country where beautiful languages are there, a country where you can speak number of languages. We have forgotten. We speak half-baked, half-truth English now. Half English, half Marathi, half Tamil, half Kannada, and again half English. So in the meanwhile, what happens? What you want to drive will miss. You are not expert in any language, finally. Be an expert in your mother tongue at least. That will save you to learn many languages. Unfortunately, that's another problem. Then the big data and the software that is being created through hardwares and programming systematization of program that is being made in directing the robots. If the software is corrupted, like robo movie, the robo becomes erratic. Then whom do you blame? Do you blame science? Do you blame misusers? Both are responsible. So how do you take protection mechanism? And what are the protection mechanisms should be taken? How we deal with the various perspectives? That means vulnerability. 2 minutes,
I'm sorry, Professor Shastri. I think we have some time limitation. I would request you to please a little.
Only 2 minutes I conclude. I'm not taking
so
much
grateful
time.
to you. So grateful,
Well,
and I'm extremely sorry for this.
only just two minutes, I'm concluding.
Please continue, sir.
Yeah. See, then when we think of all these things, what are the rights that are going to be affected? I'll not go into details. I'll simply summarize. Right to life and liberty, security, equality before law, fair trial, that is criminal justice, and freedom from discrimination, and then freedom from arbitrary arrest, detention, and right to privacy. These are the effects that are going to affect very much with artificial intelligence. We bring in, and most important right that is going to be affected among all the rights is right to education, right to adequate standard, right to safe living, peace and security. And all this results in impropriety in democracy of making or doing anything with respect to elections, with respect to fair poll, fair voting, and right to comfortable living. These are the major human rights or fundamental rights that are going to be affected, for which solutions can be identified through ethico-moral perspectives by advocating and teaching human rights values, human rights education, because from 94 to till date, the human rights education is made a very world important perspective. Every institution should teach human rights education right from childhood. Then the technological developments that takes place under Article 15 can be very well protected. Thank you, one and all.
Thank you, Professor. Thank you, Professor Shastri. It was really enlightening, and the crux of the matter, as you said, ethico-moral values. No doubt, without that ethico-moral values, we can, this will certainly overpower us. We'll come to some questions also, which are there in my mind, and we'll take that later on. And before moving ahead, I would like to welcome our another next speaker, who's from Netherlands, Mark Watman, who's CEO of Watman Consultancy. Most welcome, Mark Watman.
Hello, good evening for you, good afternoon here.
Very good afternoon, and we really welcome you and the entire panel out here. People are waiting to listen to you. Thank you.
Thank you very much. Yeah, distinguished panelists and distinguished attendees. It's great to see such a big audience at this conference on an important topic. My name is Mark Wortman. I'm actually here as a board member of the organization Global Human Rights Defense, which is based in The Hague in the Netherlands, the city that says from itself it's a city of law and peace, because there are many legal and justice organizations based nationally and internationally. Our organization is an NGO that works internationally, and our mission is to actively promote and protect the human rights of minorities and marginalized groups, and to enhance their socio-economic empowerment by educating, advocating, and influencing. GHRD monitors human rights violations and utilizes collected information to advocate and influence changes in policy making, and educate a variety of stakeholders to decrease human rights violations. We envision a world where the rights of all minorities and marginalized groups are respected and upheld in accordance with national and international laws, treaties, and agreements. And I must say I'm here to replace our chairman, Mr. Sital, who had an urgent call from his work and he wasn't able to make it. So he asked me to replace him. So it's a bit his presentation as well. With regards to artificial intelligence, we can clearly see that it has a lot of advantages. For instance, when using for weather forecasts, although they're only fit for 14 days at the moment, but also in medical research, an area where I have been involved in the past. AI is used a lot during the pandemic, for instance, by predicting how COVID variants will spread and how quickly a new variant becomes dominant, as we see now with the latest development of Omicron. However, we do have concerns about how artificial intelligence can violate human rights of citizens, especially those in a marginalized position. We have had a bad example here in the Netherlands in the last years of an algorithm that was used to identify potential fraud with receivers of childcare allowance from the government. Far too many people were supposed to abuse the allowance, according to this algorithm. And it became such a scandal that our government had to step down, not only because of the artificial intelligence, but it played an important role. And they're still looking into ways to improve it. But we are also concerned about state surveillance and how that affects minority groups. And some of the most critical examples can probably be found in parts of China like Tibet or Xinjiang. Another critical issue is the use of spyware to hack mobile phones of journalists, something that became known as the Pegasus project. So there are two sides on artificial intelligence, and there's not much yet a discussion on what kind of regulation is needed. Interestingly, some high-level officials of the United Nations took a firm position on the issue of artificial intelligence. In 2019, in what was called the highest aspiration, a call to action for human rights, the Secretary General of the United Nations recognized that the digital age had opened up new frontiers of human welfare, knowledge, and exploration. But he also underscored that digital technologies provide new means to advocate for, defend, and exercise human rights. And new technologies are too often used to violate rights, especially those of people who are already vulnerable or being left behind. For instance, through surveillance, repression, censorship, and online harassment, including of human rights defenders. The digitization of welfare systems, despite its potential to improve efficiency, risk excluding people who are the most in need. As the previous speaker already said, you don't find the human rights in five-star hotels, but the people who really need support, they depend on it. The High Commissioner of the United Nations for Human Rights, Michelle Bachelet, made some recommendations on September 15th of this year. And she even called for a moratorium on the sale and use of artificial intelligence systems until adequate safeguards are put in place. She suggested, and I quote, expressly ban AI applications that cannot be operated in compliance with international human rights laws, and impose moratoriums on the sale and use of AI systems that carry a high risk for the enjoyment of human rights, unless and until adequate safeguards to protect human rights are in place. I think this is very radical, and it's not going to happen at all, as artificial intelligence has too many benefits for mankind. But it's a sign of concern that should make us think about better ways to protect the privacy of our citizens. In the meantime, I was thinking when preparing for this session about one of the first science fiction books I read. That was a book called I, Robot by the writer Isaac Asimov. And it was written between 1940 and 1950 and published in 1950. So more than 70 years old, when there were hardly any robots yet. He created 3 laws of robotica, of which the main is that a robot is not allowed to hurt a human being. I think it's very interesting and still very up to date. But the application and the implementation of these laws has not happened yet. So a very much recommended read. Thank you for your attention, and I hope to take part of the discussion later on. Thank you.
Thank you, Mark. It was indeed a short and very crisp discussion from your side. So kind of you. Thank you very much. And now I would request to Honorable Ladyship Justice Anu Shiva Ramanji. She is a judge in Honorable Justice Anu Shiva Ramanji is a judge in Kerala High Court. It's a great honor to be with you, ma'am, and most welcome.
Thank you
Please,
so much.
we all are waiting for your kind words.
Good evening to all the panelists and the audience joining from India. A very good afternoon to our panelists who are joining from Europe. Thank you very much for the organizers of this event. I'm very happy to be a part of this event today. This is more so because I believe that a talk or a dialogue on the roadmap to ease the interconnect between human rights and artificial intelligence is, as a matter of fact, it is being delayed beyond the absolutely essential. I'm very happy that an attempt is being made today to at least understand the problems, discuss them, and lay down what you call a roadmap. This is a wonderful initiative. I'm also extremely happy to be part of this symposium. I do not claim any expertise in the field of artificial intelligence, but as a lawyer in constitutional law for 24 years and a judge in a constitutional court for 6 more, I would say that the perspectives of a constitutional lawyer and a jurist in the question of easing the interconnect or easing the problems in the use of artificial intelligence and its interventions in human rights law is an extremely important contribution. I will not attempt any discourse on what is human rights law, its history, or its growth. But I would only say that human rights laws, the law continues to grow with the interventions and interpretations by constitutional courts, the international treaties and conventions, then which address the key areas and the problems. And a principal area of development as far as human rights law has been concerned in the recent times has been the law relating to privacy. So here, when we speak about the interaction between human rights law and artificial intelligence, I do not intend to go into anything else with regard to artificial intelligence except the interaction between the human rights and the threats as I see it. I would say that the immediate threat, the most immediate threat, which we are already facing, is with regard to the privacy of the individual, the right of choice. As Professor Shastri rightly mentioned, when you're interacting with social media, with the forms of probably the beginnings of artificial intelligence which we have now, there is, of course, in theory, the option of consent. But is that in any way a proper or informed consent? The answer is clearly in the negative. When there is so much of fine print which is put onto the screen, and you are given an option to say, I agree or I don't, then, and the entry into the app or whatever is dependent on your agreement, then that does not make it any kind of an informed consent with regard to what you intend to share. Why is it so difficult to say what all that fine print means? What are you going to do with what I give you, with my data? Is it that difficult to inform me so that I can actually make an informed choice of consent or not? It is not. It is only that it is chosen to be withheld. The history of mankind, when we look at it, has always been a history of conflicts. There has always been, the first conflicts probably were between man and nature. Then came the conflicts between man and animals, between man and the haves and have-nots. Then again, we heard about the techno-savvy and the technologically disabled. Probably sometime in the future, we've always, as children, we've read about so many, we've read science fiction where there was the conflict between man and artificial intelligence. That may be coming to a pass sometime in the future, in the foreseeable future. Anyway, the issue was with regard to the use of artificial intelligence insofar as it affects human rights. And there we find that data is of paramount importance here. And data is what is the commodity that is being bid on, and where the wars are going to be fought on. Any activity which is used to make devices and machines think and act like humans is said to be artificial intelligence. So there again, we have a problem. When you say think and act like humans, there in human minds also, there are these biases, discriminations, the preconceptions. And these are the things which are fed into the algorithms, which ultimately make the decisions. So when a human mind is involved, there is more than just the processing of data involved. There is much more than that, where a human mind processes, as in the case where a judge judges. There is so much more involved in the sense that there is discretion, there is discerning power, there is sympathy, there is apathy. These are evidently those things which are going to be lacking when it is artificial intelligence which is making the judgments. The artificial intelligence makes the judgments on the basis of the data and the algorithms and the programs which are fed into it. Therefore, these other aspects, the human aspects that I mentioned, would be sadly lacking where artificial intelligence is concerned. Therefore, when we say that we cannot do without artificial intelligence, in the sense that in several fields, the progress we have achieved is largely due to our use of data and artificial intelligence to process the same. While we accept that like in the medical field, even in forensic medicine, in so many other fields where technology is advancing, even in politics, where the data is used to predict voter behavior. To a much greater extent, the predictions appear to have come out much better than the predictions that are made by human beings after a knowledge of a lifetime. So therefore, the use of technology and artificial intelligence, we cannot deny that there are some areas where they are absolutely essential. Crime detection and prevention. Then in the prison systems, when you have the data and you can calculate as to how many years a person has been behind bars and on what charges and how many are under trials. There are so many things that we can look into. And we can use artificial intelligence to aid human rights as well, where violations can be corrected, checked or corrected by the use of artificial intelligence. But we do not see the situation where the artificial intelligence as itself is causing the violations as well. So these are things we must balance, we must see. And another important aspect, according to me, is the loss of human employment, which is likely to come to a pass by the rampant use of artificial intelligence. These are some things some of these things are absolutely inevitable. We cannot stop these effects from occurring, because when we remember maybe 20 years back, when the computerization drives were on, there were protests on the ground that it would lead to a loss of jobs. Yes, it did lead to loss of jobs. But when the larger public interest is served and there is speed in attaining, because the numbers are increasing in all fields, especially where we are concerned in the judiciary and in the legal profession, where the numbers, the dependency is increasing day by day, where we cannot refuse to use technology insofar as it aids in the process in any manner. We have to use technology. But then the larger question of how many jobs and at what levels. In the medical field also, you could see that very skilled persons may become redundant after a while. As far as we as lawyers and jurists are concerned also, with regard to the initial advice, legal advice is concerned, we may be rendered redundant. This is something we have to accept, we have to look at and see how the way forward is. So these are largely the matters that we must look into while considering the creation of the roadmap. According to me, I would say that what is of primary importance insofar as the right of privacy is concerned is definitely the question of informed consent. We must have a roadmap where the program or the artificial intelligence algorithm or whatever does not confuse us with all kinds of texts which we do not understand, which we do not have the time to read and to give an informed consent. We must be told specifically what data is being accessed and what it is being used for. This, I would say, we are well supported by the conventions, by the United Nations conventions, as well as the decisions of our courts with regard to privacy rights, to say that the data that we are making available online should not be used without our specific consent for any purpose whatsoever. This, according to me, is the first step from which we must start. Therefore, I will not prolong on all the other steps which could be taken by us. I think this is the starting point where privacy is concerned. This definitely is the starting point. Be you a patient, a user of a program, person, just a member of a public who's a statistic in a program, you must be told that your data is being used, what specific data is being used, and for what purpose. Without which it should not be legal for any program to have any access to your data whatsoever, your history, your search. We are living in an age where privacy in all its senses is completely compromised. Therefore, this must be addressed, and according to me, this is the first step. Thank you very much. I'll reserve more comments to the question and answer session. Thank you.
Thank you very much, Honorable Justice Ladyship Shivaji. Yes, thank you very much, ma'am. It is indeed, it was really
I think there is some technical glitch from Sir's end. Thank you, ma'am. Thank you so much for enlightening us on the topic. Ladies and gentlemen, please allow me to welcome the next speaker of the session, Dr. Loti Lam, the Senior Advisor on Artificial Intelligence and Human Rights. Over to you, ma'am.
Thank you very much, and thank you so much for the really very warm welcome that we've all received to this wonderful conference. Could I ask, may I share my screen with some PowerPoint slides?
Yes, ma'am.
Okay, thank you. I'll just do that quickly. Okay, so I hope you can see everything fine.
Yes, ma'am.
Great, perfect. So I've really enjoyed listening to the previous speakers, and I take a slightly different perspective in my own research. But I'm really delighted to be here to discuss it. And my presentation will focus on clarifying corporate human rights responsibility for artificial intelligence, and specifically taking a law and governance approach. So I will focus on the need to take a law and governance approach if we really want to kind of create a coherent roadmap towards human rights protection in relation to AI. And then I will explain what I mean by this approach and give a brief summary of my findings so far as to what a law and governance approach can tell us about corporate human rights responsibility vis-a-vis AI that a legal approach cannot tell us. So we know already, we've heard from the previous speakers that there are many risks that AI poses to human rights, and there are many challenges to achieving effective human rights protection in the era of AI. So I won't repeat those points, but the problem that I would really like to focus on centers around two main points. So first is the central role that businesses play in the development and the deployment of AI, which gives them a huge potential to impact whether or not an AI system negatively affects human rights. Second is the lack of a legal certainty in international human rights law concerning AI and human rights more generally, and then AI business and human rights more specifically. And this is the main legal problem that I'm addressing in my current research. So within international human rights law as it exists today, there is no explicit mention of AI in primary legal sources. So I think here of international human rights treaties, customary international law on human rights, and general principles of international law. So what we're left with are subsidiary sources and primarily judicial decisions and authoritative interpretations of primary legal sources. And in other words, we rely on interpretations of existing law to tell us how the more general standards found primarily in treaties apply in the context of artificial intelligence. And this actually isn't anything new, but the problem is that although there have been a few cases at the national and regional levels that show how the right to privacy in particular can apply in the context of AI, these are limited, and we don't have any judicial decisions at the international level yet. We do have a few significant contributions from various UN human rights bodies that consider how international human rights law applies to AI. And we already heard from our colleague about these, especially the report by the High Commissioner for Human Rights. And there is a growing momentum here. So we also have a couple of general comments from UN human rights treaty bodies that discuss AI and human rights, with one even going so far as to discuss the role of the private sector, although this does remain relatively limited. The same can be said of the report by the High Commissioner. This again mentions some of the responsibilities of AI businesses, but it's again quite limited in its scope. So there is some progress here, but there's still a lot of work to be done. There are still significant gaps and unknowns about how exactly obligations under international human rights law apply in this context. And the uncertainty is really particularly evident for businesses in relation to businesses that are either developing or using artificial intelligence. And this is because the legal framework for business and human rights is still evolving. And as I'm sure you already know, businesses do not have any binding human rights obligations at the international level. So at the moment, we rely on non-binding standards, such as the UN Guiding Principles on Business and Human Rights, as well as some piecemeal and sometimes inconsistent national legislation that applies to businesses. And we rely on these to tell us what human rights standards these businesses should be following. And one of the problems related to this is that the non-binding standards, and especially the UNGPs, are very general, and guidance is needed for businesses to learn exactly how they apply in the context of AI. So all of this leads to a lack of legal certainty for businesses who are not sure what they have to do to comply with human rights, and also for potential victims who don't know under what circumstances they can claim a violation of their rights. And all of this has a knock-on effect for accountability and access to an effective remedy for victims. So in my research, you could really call it a quest for clarity. So I wanted to know what businesses developing and using AI should be doing in relation to human rights. And since you can't find the answer in international human rights law itself, I take a law and governance approach. And this means that rather than looking only to law to solve a societal issue, a law and governance approach actually considers extra-legal and less formal activities conducted by a wide range of actors. So under the approach, governance is understood as the drafting, adoption, implementation, and enforcement of rules or standards, and the mechanisms, tasks, processes, and institutions that exist to achieve these tasks. So this means that it could include, for example, unlike a purely legal approach, policies, guidelines, and self-regulatory initiatives taken by businesses themselves. An important point to note, though, here is that law is not ignored in a law and governance approach. It's still very important. It's considered to be an instrument of governance. But the approach does allow the current realities of governance, which is often delegated to or taken up by actors beyond the traditional governing entity of government, to be considered. So here we can talk of shifts of governance from governmental to other, sometimes private actors that have a role in each of the governance tasks that I mentioned. And we see this happening a lot in relation to artificial intelligence, especially in relation to standard setting, but also other governance tasks as well. And as you can see on this slide, this includes international organizations, states, independent expert bodies, NGOs, and business enterprises. And in total, in my research more broadly, I've analyzed around 100 initiatives, many of which deal with at least some aspects of human rights. And for the research I'm presenting today, I restricted my analysis to initiatives that mention applicable standards for businesses. And I analyzed in those kinds of initiatives at the international and the regional and national levels. So the aim here was to identify what standards businesses should be held to in relation to human rights and AI. And the findings show that overall international level initiatives seem to be more direct in taking a human rights-based approach, engaging with a broad range of human rights and sometimes direct responsibilities for businesses with regard to human rights. Sometimes that's very general. So it's just a passing reference to the need for businesses to respect human rights. But some initiatives have been very elaborate in the standards that they impose on businesses. So this can include, for example, human rights due diligence and impact assessments, transparency requirements, stakeholder participation, and mechanisms for accountability, such as auditing. Although internationally no legally binding initiatives have been taken yet, we do see these being taken at the regional and national levels. So at the regional level, very little action has been taken beyond Europe. And here the conduct of businesses has been addressed very directly and sometimes in detail, but usually without labeling these standards as human rights standards per se. At the national level, there is a much broader geographical range of initiatives than regionally, but relatively less explicit discussion of human rights beyond privacy and data protection, and more recently also non-discrimination. So within this context, various legal standards are applicable to businesses, but it's a bit more limited in scope compared to the international level. And this is my last slide here, just to round off and give some reflections on the findings. Quite a number of standards have been laid down for businesses to follow that can arguably significantly contribute to the protection of human rights in the context of AI, whether or not these are actually explicitly framed as human rights responsibilities. Consensus is emerging on certain points within the different levels, although the only standard with consensus across all three levels was transparency. And this is most commonly in the sense of informing end users when they interact with an AI system or when a decision about them is made using artificial intelligence. Overall, then, and coming back to the idea of this law and governance approach, and particularly one that understands governance as going beyond government, this allows us to more easily learn and understand what AI businesses should be doing than if you take a purely legal approach here. And one reason for this may be that without the confines of the international human rights law framework, which is very state-centric, such governance initiatives at various levels are able to focus less on what kind of factor is addressed by initiatives and more on the end result to be achieved, which is the responsible development of AI, including the protection of human rights. And in turn, this allows such initiatives to lay down the standards to be followed to achieve that result, regardless of the identity of the addressee of those standards, whether states, businesses, or other relevant actors. So I will leave my presentation there. I very much look forward to the rest of the discussion and the question and answer session. And thank you so much again for having me here. I'm really delighted to be part of the session. Thank you.
Thank you very much.
Thank you, ma'am. Thank you so much. It was indeed a very thought-provoking session from all our esteemed speakers. And now the much awaited moment that we have arrived, wherein our students get to ask questions to all our esteemed dignitaries on dais. So the first question that we have, it's from Mahima Pillai, and the question is for Mr. Mark Watman.
Am I audible?
Yes, you are. Mahima, I just need to cross-check. Yes, sir is there. Yes, Mahima, please go ahead.
Yes, ma'am. Greetings to one and all. My question to you, sir, is, can artificial intelligence be the tool for prevention of discrimination amongst human beings?
That's a good question. It would be wonderful if it could. But I think discrimination is always something that should be judged by humans. I cannot imagine a system where AI can take that over from us, because you have to understand the context. Yeah, so unless computers get so clever that they can make a judgment for us, but I don't think so. I hope not, actually.
Okay.
Yes. Thank you,
Okay,
sir.
Yes, thank you, sir. Thank you so much. The next question is from Ovia, first year BBLLB honors student, and the question is for Justice Madam. Ovia, over to you.
Yes. Greetings, everyone. Am I audible?
Yes, you are.
Yes, you are.
How can we guarantee the right to work and protection against unemployment of averse to the increasing usage of artificial intelligence?
Ovia, that exactly is one of the concerns where the use of artificial intelligence increases. But we must also understand that some of the things that we use artificial intelligence for are things that human beings are unable to do, at least not able to do within the very limited time that it takes artificial intelligence to do it. Therefore, if, say, suppose you want the entire data of all the courts in the country to be gathered to see what the violations of maybe in the sense discriminations are, the complaints of discriminations which are pending in all the courts in the country. This is something once the data is made available. This is something that a bot can probably do without, I mean, artificial intelligence and algorithm can do within probably even seconds. And this is something we have not been able to do in spite of all our years of work as human beings. So this would not be something that you are taking from the workforce, the human workforce. So most of the work that artificial intelligence would be enabled to do are things that we are not able to do by ourselves. Therefore, as far as like Professor Mark just said, there are some areas where it may not be possible for the artificial intelligence to perform. Those are areas where we would still be needed. So heaven forbid, everything is not going to be taken away from us, and artificial intelligence is not probably be able to do everything that we do. But when artificial intelligence is enabled to do something in a fraction of the time that we take, then it is not a question of the human being displaced. It is a question of larger public.
Thank you, ma'am. Thank you so much for explaining the question with so much clarity. The next question is for Professor Dr. T.S.N. Shastri, sir. The question is from Kabir, a second-year LLB student. Kabir, over to you.
Thank you, ma'am. The question is in regards to providing sensitive information, sir, which you mentioned during the deliberation. What is the line of difference between giving information for our comfort and giving information that allows them to control us?
Could you just repeat the question? I couldn't get it completely.
Sure, sir. What is the line of difference between giving information for our comfort and giving information that allows them to control us?
Well, information, if you go into various details of informative process, well, information control mechanism has to be developed. As Madam Lane and Madam just made it very clear that the laws and regulations have to be developed on one side, because today in this contemporary world, there is no strict mechanism to implement the regulatory perspective of various things. 1. 2, to control information and to preserve and restore and keep information, there is no internationally binding treaty or a regulation, either in international law or in international law of human rights, or in international law of intellectual property rights. So one has to find soul-searching questions how to deal with from the legal perspective of each country and sharing with the various aspects. 1. 2. The World Intellectual Property Organization is already working on developing a international convention on protection of cultural property. This convention drafting started already 7 to 8 years back, but still they are not able to achieve, because the question which you have exactly asked need to be soul searching. Maybe the WIPO is thinking of the various perspectives, how to regulate the informative mechanism that is developing, particularly artificial intelligence. That is the reason why I have concentrated on my lecture. First, learn the ethical value, moral principles of human rights and deal with it. For example, right to privacy. If you take, how do you protect privacy? Privacy is public privacy, private privacy. There are two important distinctions of that. Privacy is horizontal and vertical. Same way, artificial intelligence is also artificial and horizontal and vertical. So which one has to be used, which one has to be controlled, mechanism has to be developed both, as Madam Lane said, at the international level, regional level, national level, and synchronization of these principles with the fundamental principles of human duties should be taught. Duty consciousness world has to be made. Then only we can protect anything, either information or anything. Otherwise, it's very difficult.
Thank you, sir. Thank you so much. Kabir, I hope that suffices your query.
Yes, ma'am. Thank you.
The next question is from a fourth-year BBA or LLB honors student, and the question is for Dr. Loti Lane. Asha, you can ask your question.
Am I audible, ma'am?
Yes, you are.
Ma'am, the question is, will the improvement and innovation in artificial intelligence cause a threat to the right of privacy of an individual?
Yeah, absolutely. I mean, we heard also from other speakers that the right to privacy is hugely threatened by the use of artificial intelligence. And for me, one of the big concerns also is that there's insufficient attention being paid to this in regulations or in AI initiatives that are being developed in relation to businesses specifically, because I mean, as I said, businesses have a huge role in the development of artificial intelligence, and it's unclear at the moment. We have some advice on how privacy applies to states, but how privacy applies to businesses and AI is less developed at the international level. And so we really need to pay attention to this in order to try to prevent these kinds of risks to privacy that we've seen ongoing in the past, but also, of course, in the future. And we need to make sure that, that this is one of the key human rights issues that needs to be addressed. Yeah, I hope that answers your question.
Thank you, ma'am. Thank you so much. And the last question we'll take up from Vivekanand, the second-year BBA LLB honors student. And the question is for our moderator, Advocate Sanjay Kumar Chaddaji.
Greetings to everyone. Am I audible?
Yes, you are.
Yes. The question is, can the artificial intelligence be able to differentiate between human emotions, morals, and human rights? Will they be capable enough to combine all these together? Thank you.
If you ask me, I would say no. It will not be able to match the morals and all those things. It cannot, because it is something as what is artificial intelligence? All of us know that very well. So it is not where the rational, where the reasoning, where the intelligence is involved. And that is the reason, as Ms. Lane was saying, that internationally as well as domestically, the law is still very weak. But the judgments like Justice Puttaswamy judgment, all of you are aware of that. This is from our Supreme Court. 9 judges bench has given this privacy law judgment. In that, we have developed, we are evolving, and as Honorable Justice Anuji has said, that from the very beginning point, the data protection, as she said, So from data protection to further, when we move ahead, we have to, and the law is growing. Law, law, as all of us are well aware, law is dynamic. It grows as per the need of the society. So certainly, the reason I said, rational reasoning, intelligence, all that thing, morals, etc., can't be, you can't match it with artificial intelligence. That's all. I think I have answered your query.
Yes, sir. Thank you, sir.
Thank you.
Sir. Thank you so much. Like my chat box, don't take up 2 more questions. So with the permission of the chair, please allow me to take 2 more questions. One of the question is from Nandini Ravi Shankar, and it's for Justice Madam. Nandini, you can ask your question.
Thank you so much, ma'am. Greetings to Honorable Justice Anu Shivaraman, ma'am. When we consider artificial intelligence and somewhere associated with precedents, which all these years the judiciary has been taking into consideration, artificial intelligence, when you said that the machines can just understand what a human being feels. So when precedents cannot be imbibed by the machine, doesn't that become a problem while giving judgments?
Well, I would like to, I'm not too sure about the assertion that artificial intelligence cannot understand precedents. That may not be correct, because even when the data is available, why do we assume that the artificial intelligence will be unable to process it? That the precedent is available. If the body of precedents is available, definitely I think that the artificial intelligence will be able to process it and understand the data which is involved and understand precedents also. And with regard to what the moderator said in reply, to a certain extent, how a person reacts to particular situations, from what I know, are also things that can be fed into artificial intelligence so that it understands some of it definitely may not substitute for human emotions. But I do feel that some of our reactions and some of our, like I said, the predispositions, and these are things that definitely can be fed into artificial intelligence. As far as I know, precedents definitely, these are data. Precedents are in the form of data. There may be conflicting precedents, and it may be for the discerning judge to apply the precedents in a particular manner to the facts of the case. But we should not assume that artificial intelligence would be absolutely disabled from doing any function which requires discretion. If it is fed with the right data and if it is given the right kind of capabilities, much of what is being done by the humans today can be done by the artificial intelligence also. However, what would be lacking would be the human discretion. We probably may also see a stage where a part of the discretion can also be a part of artificial intelligence, can also be fed into artificial intelligence. Let us not write this off as some kind of just an algorithm which just goes about doing this. That is, I think, a view which is getting outdated. So precedents, according to me, definitely, their data, they can be fed and they can be understood by artificial intelligence. Thank you.
Thank you, ma'am. Thank you so much. And the final question we'll take up is from Advocate Aditya Gore, and the question is for Dr. Shastri, sir. Artificial intelligence to create a central repository of fundamental right violations, as can be gathered from writ petitions filed before different high courts, so as to advise the policymakers on how the law could be reviewed.
Repeat. I could not get it because the audio not visible clearly.
Yes, sir. The question is, could we use artificial intelligence to create a central repository of fundamental right violations so as to advise policymakers on how the law could be reviewed?
Well, the law is evolving. It needs to be protected, and it is not only the law. I can only give you one single sentence answer. Where there is science, technology, which is where there is a culture, there should be a perspective to honor and respect and participate in cultural perspective. If that is been done, whether law is there or not, you can do it, because a number of laws come. Protection and development of are the various perspectives of human rights through artificial intelligence. Today, artificial intelligence, tomorrow maybe space science. That's another way which is developing. So only single line answer is that we have to abide by the cultural perspective norms of rights and duties. If we are not, whatever the law or legal regulations, either at international, regional, or national level you make, there will be violations. And taking by few violations, we cannot generalize and say the cultural perspective of technology and technological developments are creating destruction.
Thank you, sir. Thank you so much. And thanks to all the dignitaries for answering so many questions with so much patience. My dear students, we have come to a very, very important part of the session, which is the passing of the resolution. The resolution for this session is: we, the participants of the first International Symposium on Law and Peace, hereby appeal to all the stakeholders to integrate adherence to the human rights laws in practicing the artificial intelligence so that the sanctity of the right to dignified life guaranteed under Article 21 of the Constitutions is respected and protected. My dear students, you have 1 minute time to cast in your votes, and I'm sure you will not want to lose out on this opportunity of voting on such an important resolution. We, the participants of the first International Symposium on Law and Peace, hereby appeal to all the stakeholders to integrate adherence to the human rights laws in practicing the artificial intelligence so that the sanctity of the right to dignified life guaranteed under Article 21 of the Constitution is respected and protected. We just have a few seconds left and we will be having our results. All the students, please cast your votes. And almost we are about to get the result for this particular resolution. And the votes are about to come in. With bated breath, we are all waiting for the votes to come in. And it's finally here. 99% of the students have given their votes in favor of the resolution. Thank you so much for your participation for the passing of this resolution. Thank you so much. Now we have come to another very important part of the session in which we administer oath. As human beings, as citizens of this country, as being the sons and daughters of the Mother Earth, we have certain duties towards our Mother Earth. Now, I shall request Mrunmay Jodh, first year LLB student, for taking the oath. Over to you, Mrunmay.
Am I audible?
Yes, you are.
Good evening and good afternoon to esteemed guests, respected teachers, and my fellow mates. It is indeed a golden responsibility to read aloud the oath for every one of us. I would request everyone to take the oath while I read aloud for you all. On the platform of MITWPU International Symposium on Law and Peace, we, the sons and daughters of Mother Earth, being a global citizens, assured to abide by the duties and responsibilities of an ideal citizen, and hereby affirm that we will endeavor to promote peace and harmony, through the lens of law in the pursuit of justice. Thank you.
Thank you, Mrunmayee. Thank you so much. We are almost towards the end of the session. I shall now request Mr. Dheeraj Singh, Director, School of Media and Journalism, for rendering a vote of thanks and for the concluding remarks. Over to you, sir.
Thank you, Dr. Basu. Thank you so much. At a time when most of our online decisions are being made by artificial intelligence, the topic that was chosen for the session today is very, very apt and very pertinent to our times: human rights, law, and artificial intelligence. At this juncture, when the machines that we have created have posed a serious question mark to the way we conduct our lives and the way we do businesses in our present contemporary society, it becomes very important that law, or people who are in the profession of interpreting legal frameworks, also come forward and put their thoughts in front of our students who are getting their very, very valuable first step or foot in the door of this new legal ecosystem that we are facing right now. So thank you so much, School of Law, for thinking of this wonderful theme for the session today. And on behalf of MIT World Peace University and our founder, Dr. Vishwanath D. Karad, and our executive president, Mr. Rahul V. Karad, I would like to extend a very, very warm and hearty thank you to all our panelists, especially Advocate Sanjay Kumar Chaddha, who is a managing director at BSK Legal, for setting the tone to the session by sharing from his own vast courtroom experiences. I'd also like to thank Professor T.S.N. Shastri, who's a founder, Vice Chancellor, National Law University, Sikkim, for bringing to the fore the questions about ethical and moral perspectives that need to be thought of, especially in view of AI. And these should be made part of the higher education in law at universities and legal institutions. I'd also like to thank Mr. Mark Wortman, CEO, Wortman Consultancy in the Netherlands, who took us back into the past by talking about Isaac Asimov's wonderful classic book about AI and human interaction, and how human rights are so finely ingrained into this whole debate about human rights. And it was imagined and sort of prophesied so far back into time by this wonderful writer that he mentioned. I'd also like to thank Honorable Justice Anu Shivaraman, Justice of the Kerala High Court, where she mentioned very clearly about online consent and how it was so important, especially in our time when we are signing off our privacy to so many vendors who do not explicitly state how and what we are submitting when we subscribe to them or follow them. I'd also like to thank Professor Lottie Lane, Senior Advisor on Artificial Intelligence and Human Rights at SLIMR at the International Law Research, Human Rights and AI Netherlands, for bringing in a very moot question of how businesses whose business it is to introduce AI-related software into the way we function in our times today, and how there needs to be more clarity on the issue of how businesses develop software which increases the engagement of AI in our lives today. So thank you once again for bringing your extremely well thought out assertions and arguments, and also your expertise from your various fields. I would also like to thank Professor Anuradha Parashar, Dean, School of Law, Faculty of Liberal Arts and Visual Arts, for organizing this wonderful session and thinking of these very, very key issues concerning the legal fraternity in our contemporary times. Thank you also the anchor of the session, Dr. Chayanika Basu, for leading us into introducing the session to our audiences. And again, a big thank you to all the students who participated in this wonderful session. Thank you.
Thank you, sir. Thank you so much. My dear student friends, before we sign off from this session, a very important announcement for you. The final session, that is plenary session 8 for the International Symposium on Law and Peace, is scheduled tomorrow at 2 p.m. And I'm sure, just like you benefited from all the previous 7 sessions, it is going to be an enriching session as well. On that note, a heartfelt thanks to all the dignitaries who could take out time from the hectic schedule and could be a part of this conference. Heartfelt thanks to Dr. Dheeraj Singh, sir. And of course, our ever-inspiring, beloved, our Dean Ma'am, Professor Anuradha Parasar. On that note, we will sign off from this session with the universal anthem, the Poseidon. I request